continued our conversation around the LG autonomy. It's been in the polity, loads of commentary, things I've read, laws I've looked at, conversations we've had about this. It's groundbreaking, that judgment, milestone, if you say, because it's been a long time. There are pros and cons as all of that. You heard the governor of Kwara State saying that, oh, this is like removing burden from us. We carry a lot of burden, so it's important that they carry that burden themselves. So we'll look at all of that today on two parts of the program exclusively dedicated to this conversation, but on different aspects of the conversation. First, we'll talk the legalese. Why we've been joined, it's why we've been joined in the program by a lawyer. He calls himself an independent governance policy analyst and a friend of President Bwala Tinubu, a member of the PDP, Mr. Daniel Bwala. Is that the best way to introduce you? Was I correct, Mr. Bwala?
Unless one, I'm not a member of PDP.
Oh, you have left the PDP?
Yes, I have left the PDP.
Okay, but you're not in the APC?
I'm very close.
We'll talk about that another day. Let's talk about why we brought you here. The judgment has come. We've heard comments from everyone, literally, as far as this is concerned, for and against. But let's get your assessment of this judgment of the Supreme Court that says, look, no longer business as usual. Send these monies to the local government areas. In fact, if you're carrying any other nomenclature apart from elected officials, whether it's transition, caretaker, whatever name you want to call it, forget the money. Help us make sense of what you think about this.
So the Supreme Court is not just a court of law, but it's also a court of public policy. The world over, the apex court of the land played this dual role. There are instances where they interpret the law strictly as they are, and there are instances where they interpret the law, but then apply public policy to cure the mischief. What has been the mischief is that the clear provision of the law, which provides for joint account between the state and local government, has been abused by governors over time, and therefore governance is not delivered at the local level. And if you know the powers of the lawmakers, constitutionally speaking, they are to make laws for good, order, and good government, for peace, order, and good government. Where the law made by the National Assembly does not provide peace, or does not provide order, or does not provide good government, the judicial branch of government can strike that law, can interpret that law howsoever to give the meaning, the spirit, and the intendment of the lawmakers to the extent that it will give good governance. So the judgment of the Supreme Court is reflected in that spirit. And what the Supreme Court judgment is doing at the moment is to take governance right to the level where governance started from. Before we all came to the center, we were all from our native lands. If you look at the national anthem of recent time, we came from native land to the center. So government start from that locality. And I'm happy that governors are even appreciating it, like the governor of Kwara saying that this is even a burden that has been taken from them. I hope that other governors in Nigeria will also see it from that point of view. But this is one of the greatest breakthrough of democracy that President Bwala Tinubu's administration has brought. We've been on this journey for long. I remember even under Buhari, when he was struggling with these governors, he had to sign an executive order to give effect to that provision of the Constitution. The same governors on the platform of his own party went to the Supreme Court and challenged him. But I'm happy that this time around, that President Bwala Tinubu's administration took it to the Supreme Court. The Supreme Court gave the interpretation that will bring peace, order, and good government to the local government.
I'm going to stay with you on the issue of the laws as much as possible, and then we'll get to the politics of it. But you just heard Abdulrazak Abdurrahman, Kwara State Governor, say, we don't touch the local government funds. The AGF took them to court because they said they touched the local government funds. So what do we make of these two parallel?
Well, I'm sure that his statement is political, but there is no governor in Nigeria here who has not been touching the money of the local government. You see, because the money is domiciled in that account called the joint account, what we find, for example, in Nigeria today, we have about 21 states of the federation that have caretaker chairmen. Who are the caretaker chairmen? They are usually the special advisor, special assistant of the governor. He makes them caretaker chairman, and while they perform their duties as chairman, every revenue that goes to that local government is administered by the governor. So the governor is also the chairman of that local government, but he uses his special assistant. But the Constitution recognizes a democratically elected local government having the same functional powers as the state and as the federal government. So for the governors to say they have not been touching the money of the local government, it then means that there should be a safe conclusion that that state that is making that postulation should be able to account for, from the day they started this administration to this moment, all of the monies that go to the local government. It's about 20 point something percent in the allocation, while 26.6 or 26.8 goes to the state and 20.2 or so goes to the local government. If these monies have been going directly to the local government in Nigeria, there is no crisis in this country that will come to the center to the point where the pressure is placed on the president. We'll be able to deal with primary health care. We'll be able to deal with things that have to do with security and local education at the local level. But all of the money going to the local government have always been the monies of the governor.
So let's go to the laws now. All of this is in conversation around Section 162 of the Constitution. The issue of 162 subsection 6, I want you to help us make sense, because that truly provided for this joint account that created the whole Jack controversy. So what do we make of that provision of the Constitution right now? Because it's still there as part of our ground norm.
Yeah, so that's the provision of the Constitution as it stands. With the judgment of the Supreme Court, it means that judgment of the court is valid and the law. You see, the role of the court, which is why in the academia, sometimes when judges make decisions that correct legislation, oftentimes we call it judicial legislation. In the same way, executive orders oftentimes is referred to as executive legislation, while judicial on is called judicial. So you operate within the ambits of the law. What the Supreme Court has given, take for example, I've had divergent views and argument around that the strict appliance of the Constitution is not followed. The judgment of the Supreme Court by our law is valid and is the law, and it is binding on all authorities throughout the Federal Republic of Nigeria. And even where you think that the Supreme Court has failed, you know the dictum of the court, that the Supreme Court is final not because it is infallible, but it is infallible because it is the final court of the land. That is a democracy handed to us. In terms of strict application or interpretation of that joint account, it is for the purposes of domicility of the money. It is for the purposes of record and accountability that there is a joint account belonging to the state and the local government where these monies are going to go there. But where there is a maladministration and misappropriation of the money that belongs to the local government in the joint account, the Supreme Court has stepped in to correct that by saying the federal government is directed from now henceforth only to release monies to the accounts belonging to the local government council. And in states where there are no democratically elected local government chairmen, the federal government should not release the money but wait. So there is no controversy, there is no problem, because Supreme Court is coming from three prongs. One, as a code of law, interpreting the law strictly. Two, as a code of policy, directing public policy in government. Three, as a code that corrects the mischief. So, and this is what I believe that the Supreme Court has done. So no controversy, no problem whatsoever.
So, Mr. Bwala, this means that it's either that provision, subsection 6 or 162, is going to be expunged or amended to reflect this new reality. But there is, it's not everybody that is applauding this. I think I saw a statement from former governor of Delta State, James Ibori. He considers this as an assault on true federalism. If my producer can show me that section 2, subsection 2 of the Constitution, which perhaps is attributing this to, which talks about the federation consisting of states and the FCT. So if you see subsection 2, if they hold it here, it says, Nigeria shall be a federation consisting of states and a federal capital territory. The only time we heard of local government was in section 7, subsection 1, which guaranteed the establishment of local government by the Constitution through the state. So I want you to speak to the people that are faulting this to be like, you are violating the law according to provision of section 2, subsection 2.
So you have to look at it from, that's why in our interpretation of law, we talk about reading it either disjunctively or you read it conjunctively. The portion he's referring to must be read conjunctively. In other words, you read that in connection with other sections of the Constitution in order to have a true meaning of what it says. I will even add to the conversation section 5 of the Constitution because the president, who is the commander-in-chief of the armed forces of the Federal Republic, by law, has a duty to protect, promote, and enforce the provision of the Constitution. In fact, that was what Buhari tried to do. When he discovered that these governors were creating mischief, he signed executive order in order to enforce the provision of the Constitution. But the Supreme Court then said that that executive order would have amounted to lawmaking because he ought not to have done that. That is quite understandable. So if you read it disjunctively, you might think the import there is that you have the state and the federal capital. But if you are looking at it conjunctively, you also have to refer to the section of the Constitution that talks about the local government and refers to the power of the president to ensure that there is a reconciliation of the provisions of the Constitution in order to deliver peace, order, and good government. And that is exactly what has happened. If I go by his argument of Chief James Igori, does it suggest that the state that exists, does the state swallow the local government? Because the Constitution says democratically elected local government, meaning that they have the same powers as circumscribed by the Constitution, and they are to run the administration in a way and manner in which the Constitution provides for it. So what state government often do is that they look at the local government as a slave, that the state is the federating unit, the local government is the slave. But that is not the import of the Constitution. That's not the intendment of the lawmakers. So you read it conjunctively. If you read it conjunctively, no issues. If you read it disjunctively, then it will be subjected to varied interpretation.
For the people who are afraid that this is dovetailing implicitly into another form of central control, and I'll tell you why I said that in my next question. Is that what you see?
You said, come again?
For the people that are seeing that this is more like federal government controlling everything again from the center, not allowing the state to be a proper federating unit by this action and more action coming, is that a fear that we should be concerned about?
It's not a fair assessment. Why? Because the president did not act unilaterally. The president approached the court for interpretation. The Supreme Court of Nigeria is not a federal government. The Supreme Court of Nigeria is the body that represents the arm of judicial branch of government, whose duty it is to interpret the law and settle dispute. In this case, there is a dispute. If you look at section 2, I think 250 or so, the dispute between the state and the federal government. Assuming President Bola Ahmed Tinubu, by a fiat or by executive order, makes an order or direct the central bank and say, go ahead and deposit money to the local government chairman to themselves only, then the federal government is usurping the jurisdiction of the state. The federal government is overreaching its power. In this case, there is a conflict. It is the duty of the president, subject to the provision of section 5. His powers and duties goes across the Federation of Nigeria. He has a duty to protect the interests of the republic, right? He approached the court and said, please help us interpret. We think that this interpretation should have been this way. The state also argued in the Supreme Court. It's not as if the federal government went and made the judges and then got a letter. And then the Supreme Court gave robust interpretation. Now, I must admit, I've not read all of the judgment, but all of the analysts have not denied. They've all agreed to this fact that there was a decision by the Supreme Court to the effect that monies meant for the local government should go to the local government and only to local government that are democratically elected. In this case, you cannot say there is a usurpation of power or there is an abuse of the federal executive branch of government because the government approached the court and the court gave the order. The beauty about the sanctity of the judiciary is that the law, even if it is a wrong judgment, because it is a judgment of a court of competent jurisdiction, in this case, the judgment of the final court of the land, that means that judgment becomes a law. The only thing that may happen is the National Assembly can now legislate in order to bring clarity in order to delineate and distinguish, some of these issues. It happened now in the case of Amechi and INEC. You remember the Supreme Court decision at that time. National Assembly had to amend the law so that we didn't have to have that again. That is the beauty of democracy. It's evolution. But at every given time where there is a dispute, the judicial branch of government are the one whose duty it is to give the interpretation. In this case, it favored the federal government. There are areas and instances where judgment were delivered that never favored the federal government. Why didn't we say at that time that there is a usurpation of the authority?
All right, so Bwala, that's what brought you to bring all the legal intricacies and make sense for us. We must admit as well, we're waiting for the CTC to be able to speak authoritatively based on the reasoning of their Lord Justices and the conclusion of this. But whilst that is on, we understand some of the things that were said in court. So let's give a litmus test, for instance. That directive that if a local government official or the chairman or whatever it is are not democratically elected, they should not be receiving any form of funds. So let's use Rivers State as a litmus test. Their tenure expired, I think 17th of June. The tenure of those gentlemen expired, although there was this argument about tenure extension according to the amendment of the law and all of that. So let's just say their tenure expired, for instance. Now they have a caretaker committee. In testing the law, this new directive from the Supreme Court, how can it be, how do you put it now? How do we test it with the reverse scenario? Because it looks like a bit of almost a quagmire.
No, there is no quagmire anywhere.
Okay.
What the import of the judgment of the Supreme Court is that henceforth, the law is not applied retroactively, right? Henceforth, democratically elected local government chairmen are the ones that are recognized by law. In places where there are caretaker already, the judgment of the Supreme Court, without a consequential order sacking them, will never sack them from where they are, because there can never be vacuum in power. What will happen is that to give effect to the judgment of this court, there will be need to conduct election as soon as possible in all the states that are concerned, so that democratically elected people who assume those places will then have access to the funds. The succor, the security that the Supreme Court has given to the system is that monies meant for the states, for the local government, where there are caretaker chairmen, will be suspended at the moment until when there are democratically elected chairmen there. But the judgment of the Supreme Court without a consequential order does not suggest that the caretaker chairmen who are presently occupying the seat will vacate the seat. No, they will be in that seat until there is a conduct of local government election, because there can never be a vacuum at any given time.
All right, Mr. Bwala, let's go. If I can get back my slide, that particular, excuse me, that particular slide, the second one, on the issue of INEC conducting state elections. I want you to speak to that, because there is a call that it is not just sending monies to this local government. What about how these people are brought into power? So if I can get that slide, I think it's in section 197 or so of the Constitution, that clearly allows states to conduct elections. But what we see, for instance, now there's going to be an election. So that's a provision. You see 197 subsection 1B says state independent electoral commission and all of that is provided and can be established. So I wanted you to speak to that, because there's already a call. Even the AGF himself is calling for a way that INEC should start conducting elections, because at the end of the day, INEC chairman has raised an alarm that governor stop coronation, conduct elections. And it feels like INEC does a better job than the State Electoral Commission. Tomorrow there's going to be Adamawa, there's going to be Delta. I think sometime in October there's going to be one in Rivers, another one in Akwa Ibom, and all of that. Do you subscribe to an amendment to this law where INEC will now be conducting elections in state because of this usurping by the incumbent of local government election results, if you will?
110% I subscribe to that. In fact, we were the people that were making the argument, because bad as INEC at the central level is being conceived, worse than that happens at the state. In fact, what happens at the state is stage managing, is role play, where people emerge as the chairman. So to give effect to the judgment of court, validating the provision of the Constitution for autonomy, the Attorney General of the Federation has two options. Option number one is to also test relevant provisions of the Constitution and ask the Supreme Court whether or not, having regard to these circumstances, the national body, INEC, should not conduct the election, because the whole idea is to maintain the spirit and intent of the Constitution, and so that the judgment of the court will not be incoherent. That's one aspect. You can test the waters, and if the judgment, of course, says INEC should do that, then INEC becomes the body recognized by law for the conduct of election at the local level, pending when the constitutional amendment will be done. The second one is the constitutional amendment. The constitutional amendment is going to be a big task, because that is when the governors are going to refuse their assent or refuse to pass it in their state assembly, because this is where they will feel they have a jurisdiction to find that. So the first option, which is to test it in court, to me is a better option in order to bring about transparency in the way and manner elections are conducted for the emergence of chairmen at the local level. But in the meantime, I have advised that the president can give effect to the judgment of the court. The court was very vocal and vociferous about what they meant. So the president can direct through the Attorney General, the NFIU, the EFCC, the ICPC, and any other body like the Central Bank of Nigeria. They can create a unit in their respective offices that monitor 774 local governments and collect from the banks where all the accounts of the local government are domiciled weekly reports of the inflow and outflow. They are empowered by law to demand for this to report on this account, so that we do not come to start prosecuting people after they don't steal the money. It is in a way to prevent that. Now, when you have a unit that monitors the inflow and outflow of monies going to the local government, because it's like the case of what we call state of emergency, the doctrine of necessity, it has called for that. Now, once you have these bodies who monitor the inflow and outflow, you'll be able to stop the governor still from coming through the back door to collect the same money. Because if the president does not do that, still what will happen is that the governors will influence still their same people to come through that democratic means and use the back door to collect it. So once the president is able to take these measures, we'll be able to bring stability. The good news, the good news is that any chairman who does not come to his senses to know that he's not covered by Section 308 and decides to show loyalty by committing crime against the state or against local government, EFCC, ICPC, or any other law enforcement in the circumstance can take action.
All right, Mr. Bwala, I can't let you go without running to your tweets about this perhaps grouse, if you will, with maybe we'll leave the issue of LG autonomy to politics now, with Senator Ndume, who has been speaking about the inability to access the president. It appears that maybe all is not well within the APC ranks. And you're saying that Senator Ndume is being selfish, in your word. All of this is using Nigerians' suffering as a toolkit for his personal gain. Maybe I would like you to speak to that as well, because he's a top official of government. He's the chief whip of the Senate. At that level, he should be able to see the president.
So what I do is that before I make a comment or judgment on an issue, I have to look at it from all points of view. I've listened to a number of his interviews and his outbursts. And central in all of these things is that people do not access the president. And he put himself forward. You know, in the interview he had on Arise yesterday, he said on many occasions he meet people, the president on the way. The president will say, I don't see you. Or he will say, now your people know what make I see you. So in this case, it is about him and not about the people. But one thing that must be pointed out is the Senator Ndume, being a stakeholder, knows that if he cannot see the president to tell him anything at all that he feels is of national security or national interest, there is a Senate president you can convey the message through. There is a vice president who comes from the same state where you come from. You can pass the message through. Then there is the chief of staff to the president that you both were House of Rep members. You can pass the message. And this Senator Ndume, if I'm not mistaken, since President Tinubu assumed power, he has seen Tinubu not less than 2 times. So why must access to see the president constitute national security? You see, then it will now make people, in our law practice, we say when you bring the evidence of your good character, then the evidence of bad character becomes admissible. People will ask, at your local level senatorial district, people have tried to access you and they have not been able to do that. You have not been able to represent in delivering the deliverables to the locality. That was not an issue to you. What is an issue is to the president. You see, let me tell you what is happening before you cut me off. You see, this gathering of the clouds by former appointees of Buhari, who probably are investigated for one financial crime or the other, coming together to say they will unseat Buhari and recruiting people and getting people with aggrieved, feelings towards Tinubu to do that. It is unfair both to politics, to equity and good conscience. This man has only been there for 1 year.
All right.
You are putting pressure on him. Buhari has been there for 8 years. Where were these people?
Okay. I must thank you, Mr. Bwala. I needed you to respond to that. Maybe I'll also get Senator Ndume to come and respond to you as well on the program at some other point. Maybe pair both of you if that is possible at the end of the day. So both of you, luckily...
The only reason I talk is because he came from my senatorial district.
All right. Thank you so much, Mr. Daniel Bwala, lawyer, independent, and governance policy analyst. Thank you so much for your thought and your insight on the legalese as far as this is concerned. Thank you, sir.
Thank you as always. Thank you.